So good afternoon, everybody, and thank you very much for joining us for our webinar today, this afternoon. And this afternoon, we're welcoming Professor Boóc. Hopefully I pronounced his name right, who writes a lot on the arbitrators, and he has a strong interest in issues around liability and immunity of the arbitrator, and he's published a lot on that. And so he's going to be speaking with us today. I've put the link to his profile in the chat, so hopefully you can all see the link. If you just click on it, it will take you to his web pages. But for our purposes this afternoon, for those of you who do not know me, my name is Emilia Onyema. I'm a professor here at SOAS, University of London. I also had published on the liability of the arbitrator, the arbitrator's contract. That was my first monograph. And so we've been exchanging emails with Prof. And luckily, he accepted our invitation to come and share his thoughts and ideas with us. Prof is also he's the Vice Dean of International Affairs and Science, and he's the head of the Institute of Private Law and head of Department for Civil Law at the Faculty of Law of, I'm not going to try to pronounce the name.
No worries.
I will just say the University of the Reformed Church in Hungary. If you click on the link to his profile, you will get a fuller detail. And I think it's really important for me to also note that Prof was inducted into the Hungarian Doctor of Sciences.
Yes.
Yes, and that's an important feat. So, Prof, many congratulations. So the way we will run our webinar this afternoon is that Prof is going to share his screen, and he's going to speak for about 35 minutes, 40 minutes thereabout. I will add the slides to the chat. Hopefully I'll be able to do that. If not, we would email it to everybody. But he will share his slides and he's going to speak. Now, this is really an area that is very engaging. If you have a question and you can't wait, it is burning, put it in the chat so that you don't forget. And when Prof finishes, he would take those questions and we will continue to engage again on the chat. The webinar is being recorded. We will edit out because we started early, so we'll start it from now, and then we'll upload it onto our YouTube page. We'll make an announcement to that effect on LinkedIn. Prof, please can you share your screen and so that we can start?
Of course. Professor, many thanks for this possibility and also for inviting me. Now I'm trying to share my screen.
Your screen, which we can see. Perfect.
You can see it. Wonderful,
yes.
Wonderful. So then I can start the slides as well. So as I usually say, this is the most difficult part of the lecture. After
Thank
that,
you very much, Prof.
It goes much easier. So as Professor Emilia was kind enough to introduce me, first of all, I'm a lawyer, professor of law, also a vice dean for the time being, and which is even maybe more important, I'm quite often working and sitting as arbitrator. So I'm also a functioning arbitrator and in some cases a counsel. So I think I have some experience in the world of arbitration, and I have published a few books and papers, issues related to arbitration. Today, I would like to touch upon an issue which is, I think, one of the most important key elements in arbitration, and this is the liability and immunity of the arbitrator. The way I'm going to present it to you today would be that, first of all, I would speak a little bit about the theoretical background of immunity and liability. Then I would put up some international experience and some international, let us say, cases or examples from jurisdictions. And finally, then I would like to speak a little bit about the Hungarian situation. And as I will tell you, I have a proposal for the Hungarian legislation how to regulate the liability of the arbitrator. So in a nutshell, this is what I'm trying to sum up in a few minutes. To be very honest, I have been researching on this issue for many, many years. So of course, it is never easy to put it into a nutshell, but as a lecturer and as a professor, this is something I often need to do. I have to wrap up my content shortly. To start with, let me quote an old Hungarian scholar from the middle of the 20th century, Tihomir Fabinyi. He used to be also a Ministry of Finance and Commerce before the Second World War here in Hungary. And he has a very important book on arbitration. We Hungarian scholars regard it as the most important book before the Second World War on Hungarian arbitration. And in his handbook, Professor Fabinyi touches upon the issue of the responsibility of the arbitrator and has the view, which is, I think, a view what we can maintain and represent today as well, that it's very, very rare and absolutely not often when an arbitrator can be regarded as liable for his duties or for his commitments as an arbitrator. And as it is highlighted in this reference, on the ground that the arbitrator has omitted or misapplied the substantive rule of law when preparing his award, it's very, very unlikely that the arbitrator will be held liable. This can be, I think, considered as a sort of threshold or limitation to which we can try to build up our researches. Where are the limits of the liability? What is the edge of the liability of an arbitrator? To start with, of course, and to give just a framework of my issue, it's important to have a view on the issues, the theoretical issues concerning the status of arbitrators. And as Professor Emilia was kind enough to mention her book, when I was preparing my dissertation, I used this part of her book very much, the arbitrator's contract. In this book, Professor Emilia sums up the most important theories which are working in the world of arbitration. These are the status theory, the contract theory, and the so-called hybrid theories. The status theory tries to illustrate and tries to describe the arbitrator as a judge who has the position of a judge and who has the position of law enforcement and giving the possibility to render an award to the parties. While in the contract theory, we find something different. In the contract theory, arbitrator should be regarded as a sort of service provider who is mandated by the parties to conduct the arbitration, and at the end of the day, it can render an award. And as it is very often in life, we have the hybrid theories, the mixed theories, which are trying to combine the advantages, disadvantages of status theory and contract theory. Why is it important from the point of view of the arbitration and for the point of view, especially the liability of the arbitration? This is the next question we need to have a look at. If we are trying to have a look at the several jurisdictions and several practices in the world, we see that there are three main categories or three big categories of the jurisdictions, how they do regulate the potential liability. First one is the so-called total immunity. It's, well, at first sight, it seems to be very easy to describe what it means. Those jurisdictions which do follow total immunity say that the arbitrator is absolutely exempt from any sort of liability when providing his services and doing his duty as an arbitrator. This is the jurisdiction which apply this sort of approach. To be very honest, more or less we can say that nowadays it's perhaps only the United States, the US jurisdiction, which still applies the total immunity. Nevertheless, and I will get into details a little bit later, in the US, even we can see direction when some exceptions could be applied against total immunity. I would say the other side of the coin is the contractual liability. The contractual liability, of course, approaches the contract theory in terms of saying that since the arbitrator should be regarded as a sort of service provider who has a contract with the parties, if the arbitrator breaches this contract, then under the rules of the contractual liability, we can speak about the potential liability and the potential consequences of the breach of the contract. And finally, we have the qualified immunity, which is, I think, very interesting and maybe for the future a really engaging possibility to regulate the liability of arbitrator. According to qualified immunity, we have the position that as a main rule, as a general rule, the arbitrator is exempted from liability. So in other words, the arbitrator has an immunity, but this is a qualified immunity, which means that there are exceptional cases when the arbitrator could be held liable for special commitments, for special omissions, for several breaches, for misconduct. To some extent, we can say that, for example, the jurisdiction in the United Kingdom is using qualified immunity. What we see that those countries which are common law countries either use total immunity like the US, or they use the word of qualified immunity, while the civil law countries try to use some extent of the contractual liability, but of course the extent how much an arbitrator can be held liable is differing from country to country or from jurisdiction to jurisdiction. Now, the second issue, which is, I think, very, very important before we can speak about the potential liability of the arbitration, is the law applicable to the liability of the arbitrator. Of course, when we are speaking about law and applicable law in arbitration, there are always two things which might come up. First one is, of course, the law applicable to the contract, to the merits of the issue. The second one is, of course, the law applicable to the arbitration procedure, but there is in the shadow, so to speak, a third important question. This is the law which we should apply if we are speaking about the liability of the arbitrator. So in other words, this is the law which is applicable to the arbitrator's contract. And what I have seen during my studies and during my researches, that it does not come up very often that the parties do have an agreement on the law applicable to the contract of the arbitrator. In most of the cases, parties neglect this issue, do not deal with this issue, and to be very straightforward, it does not come up very often because it is not very often that the parties need to analyze the liability of the arbitration. But when I did my researches, I really wanted to know how we could regulate and formulate the law applicable to the liability of the arbitrator and what sort of possibilities we have. Of course, we have the lex arbitri, which seems to be a very good choice. The second choice could be the law of the place of arbitration, where arbitration takes place. And the third potential question, what I tried to see, was the law of the arbitrator's nationality. And the question immediately emerged in me, could we apply the law of the arbitrator's nationality when we want to analyze his or her potential liability? And during my researches, at this point, I tried to use a very interdisciplinary approach, something I borrowed not from the law, not from the legal science, but from the economic science, from business science, from economy, and this is the so-called game theory. As we all know, the game theory is a very important theory in mathematics and in arbitration and in economy. And the question arises whether we can use it for arbitration. And to sum it up, to put it very, very easily, we can say the following. If the liability of the arbitrators of these different nationalities would always be governed by the domestic law of the arbitrators, then we do not think that the arbitration community could act as a cooperative game, because there would be a competition between the arbitrators. Let me clarify it with a very simple example. If we have a panel of 3 arbitrators, one arbitrator is, for example, coming from the United States, where he or she enjoys a very wide, a broad immunity from liability. And the other arbitrator is coming, for example, from Arabic countries, from Saudi Arabia, for example, where we have very strict regulation and very strict rules for the liability of arbitrators. And if we need to apply the domestic law of the arbitrators to conduct and to analyze the potential liability, then the interest of the 2 arbitrators would be different, because the Saudi Arabian arbitrators would say would think, all right, if I do this or that in the arbitration, it might have a consequence according to my very strict domestic law. While simultaneously, the American arbitrator might say, okay, but I have very, very soft rules to my liability. Therefore, their interests would not be cooperative. And if I may use the game theory approach, there would not be a so-called Nash equilibrium. So there would not be such an interest that the arbitrator's interest would meet the interest of the entire panel. And I think that it wouldn't be able to serve the interest of the procedure itself. And of course, it could endanger the credibility and also the complexity and the condensity of this procedure. Therefore, my conclusion was that if we want to analyze the law applicable to the liability of the arbitrators, the best choice might be the law of the place of arbitration, even in cases when we are speaking about online arbitration. As we all know, online arbitration is becoming something very, very fancy and trendy nowadays, due to several reasons and due to several circumstances. Even in these cases, maybe the law of the place of the arbitration could be the best to analyze the potential liability of the arbitrators. And then, as I have told you at the beginning of the lecture, it makes sense to have a very short international outlook, how different jurisdictions try to regulate the potential liability of an arbitrator. A very important example, of course, is France, which is a very active player in the world of arbitration. According to French law, and I may cite the well-known Boóc case from the beginning of the 90s, it speaks about the personal fault of the arbitrator, and the personal fault could be a reason how an arbitrator could be held liable under French law. What we see here is this is a very clear contractual approach. If the arbitrator commits something, then under the rules applicable to the arbitrator's contract, the arbitrator can be held liable. What we see in another continental civil law country, Austria, it's very interesting. Under Austrian law, in most cases, if we want to make the arbitrator liable, we want to hold the arbitrator liable for his acts or for his omissions, first of all, we have to set aside the arbitral award, which is rendered or which was rendered by the arbitrator. It's a different approach because it can be regarded as a precondition to the liability or to the analysis of the potential liability of the arbitrator. And then, of course, we have some important examples from the common law countries. As I have already mentioned, in the United States, we still find an important approach which is about the broad immunity from civil liability. That means that in the US, it does not come up very often, or it comes up always never, that an arbitrator could be held liable for his acts during the arbitration procedure. Nevertheless, in the case law, we find and we can identify a very important leading case from the beginning of the 80s. This is the Barr versus Tigerman. In this case, the California Court of Appeal has ruled that an arbitrator can be held liable if the arbitrator failed to render a decision in the case. Now, what is the main message of this award? And I think it would be very important even for future legislation, not only in the US, but in other cases. The arbitrator must rule on the case in any event. And if the arbitrator fails to render an award at the end of the day, this is the degree of the misconduct to which the broad immunity shall not apply. So in other words, of course, if you put it a little bit simple, it doesn't really matter what sort of award is rendered by the arbitrator. The important thing is now that the arbitrator has to render an award, and if the arbitrator fails to render the award, then it might have a few consequences regarding the potential liability. In the United Kingdom, and of course, for you British lawyers, maybe it's not necessary to recall it, but just in a few words, the threshold of the arbitrator's liability is the bad faith. If arbitrator is acting in bad faith, then the arbitrator might be held liable. What is very important that your recent amendment to the Arbitration Act touched upon a little bit the issue of the liability as well. If the arbitrator is removed from his office or from her office, in most cases, the arbitrator in this procedure cannot be obliged to pay the costs of the procedure, because according to the Arbitration Act, this is something which should be borne by the parties. Now, this amendment contains a very important exception in paragraph 5 of section 24, which says that if arbitrator is acting in bad faith under these exceptional circumstances, the arbitrator can be ruled even to pay the costs of the removal procedure. Of course, this is a very exceptional case, but it might happen. And for me, it clearly depicts the issue that the United Kingdom is following the qualified immunity on the liability of the arbitrator. And finally, just to refer to an important case from the international case law, we have to refer to Spain. This is not a very old case. It's only 9 years old, the so-called Puma case, that was a big international case on arbitration. It had, of course, many, many branches. But from the point of view of immunity, the situation was that one arbitrator was deprived of being able to take part in the deliberation with the other 2 arbitrators, and the other 2 arbitrators reached the award and rendered the award without the participation of the 3rd arbitrator. And of course, the Spanish Supreme Court in Madrid held that this is an issue for which the 2 arbitrators must be held liable. And now we get maybe a little bit to the Hungarian part, and we have to take a look how it is regulated in Hungary and what we can do. First of all, I need to refer to the Hungarian Arbitration Court, which is attached to the Hungarian Chamber of Commerce and Industry. According to its rules of procedure, the arbitral tribunal and the members are normally exempted from the liability when acting as arbitrators, except for liability for damages caused to an intentional breach of duty or gross negligence. So in Hungary, the threshold is the intentional breach, the infringement of the contract with intent, or the gross negligence. And of course, the question always emerges what gross negligence means. I need to refer to the issue that it is very close to the regulation of the limitation of liability of ICC. This contains more or less the same threshold. There are in our rules of procedure a few little parts when we can still touch upon the potential liability of an arbitrator. For example, the minority report. This is always a very crucial issue in arbitration. It says that if the arbitrators do render an award and an arbitrator has a special minority opinion, the arbitrator might publish this minority report, but the minority report cannot contain any information concerning the internal deliberations of the arbitrators. So, I mean that those persons, those parties who have an access to the minority report can never know what sort of deliberation was between the arbitrators. And if it comes up, if it comes to light, then it clearly means that the arbitrator can be held liable for that. The second issue is what we have in our procedural rules is that if the arbitral tribunal does not deliver the award within the deadline, which is 45 days after the closing of the procedure, then the presidency of the arbitration court has the right to reduce the fees of the arbitrators in order to encourage them to do timely work and not to miss the deadline. And thirdly, this is not a rule yet, but we have a draft rule which was deliberated by the meeting of the full council of arbitrators. I mean, of our arbitrators at the end of last year in Budapest. That's a draft rule which would entitle the president of the arbitration court to reduce the honor of an arbitrator up until 25% of the arbitrator of the honorarium if the arbitrator does not follow the procedure. I mean, if the arbitrator is in huge delay or fails to cooperate with the secretary of the arbitration court, for example, if the arbitrator fails to answer to the emails, calls of the secretary, or if the arbitrator does not make hearing or cancels the hearing without any reasons. And so, of course, this is not a rule yet, but in my view, at least, it shows that the liability and issues related to the liability can have and will have a stronger rule in the future. What we also have in Hungarian judicial practice is that in Hungarian judicial practice, a very high court award thought and said that the potential liability of the arbitrator can have two branches. One branch is that up until the arbitrator is rendering the award, the arbitrator can be regarded as a service provider, and its services are regulated either by the arbitrator's contract or by the rules of procedure of the arbitration court. But then, when the arbitrator is rendering the award, the arbitrator should be regarded as a judge, and therefore, from this point of view, we cannot speak about the contractual relationship. We have to analyze the liability as a judge. And when I was reading this case, and also I have found other cases which follow this approach, it became very clear to me that this, let us say, dual approach, or let us say, approach with two branches is not the future, and it's not a way to follow. And then I tried to understand and try to identify possible ways how we can regulate and how we can solve the liability of the arbitrator. The first issue was the arbitrator liability insurance. I know that in many jurisdictions in the world, the liability insurance is applicable also for arbitrators. In Hungary, we do not have this possibility. What I thought that we could use as a basis the rules on lawyers' liability insurance, but according to my researches, this could be regarded only as a basis and not a final solution. So what I thought that if we want to follow the path of the liability insurance of an arbitrator, then we need to make possible rule for that. For example, a liability insurance could regulate the delay, the time limit issues, and then the arbitrator could be insured if the arbitrator is causing and making huge delay during the procedure. That's also one possible question. Another possible question is the decision on jurisdiction. If the arbitrator makes a bad decision on the jurisdiction, I mean, for example, if the arbitrator is not able to decide what jurisdiction should be applied, this is such a key issue against which the liability insurance could be applied as well. And all in all, then, of course, there are some excluded risks in liability insurance. For example, the intentional deliberate damage is something which is always excluded from any liability insurance policy, no matter what sort of liability insurance we apply. And all in all, then I thought that maybe the liability insurance is a possible way, is a possible path, but not the best. And then what came to my mind, and this is something how I would like to close this short lecture, is a special proposal for the Hungarian legislation. This is a proposal, and of course it has not been adopted as an act, and it has not been enacted into any law in Hungary. But what I think that since the position of the arbitrator, the status of the arbitrator, the contract of the arbitrator is not a typical contract, is I would say a special contract with special features. I think that the liability of the arbitrator should be regulated on a special way with special rules. According to my draft proposal, which is drafted as the potential words for potential sentences for an act, normally the arbitrator should not be liable for his or her acts as an arbitrator, but could be held liable for damages caused intentionally or by gross negligence. What I have also highlighted, and this is something I have gathered even from the American practice, that if the arbitrator fails to render an award, or if the arbitrator renders an award with a huge delay, which delay might cause damages to the parties, then this is a point where the arbitrator could be held liable. And of course, it's also a very interesting question whether the arbitrator could be held liable towards third persons, I mean, towards persons who are not regarded parties to the arbitration procedure, but for whom, for example, the award creates damage. In very exceptional cases, it might happen, but I do not think that there would be much practice for that. And an interesting issue is that, according to my proposal, if the arbitrator and the parties to the proceedings make an agreement in the arbitration agreement, for example, that the arbitrator's duty is to render an award which is at least enforceable in those jurisdictions which are known during the procedure, if the arbitrator takes this liability, then the arbitrator can be held liable if the award is not enforceable. Since I think that this is a very, very hard point, this is something which can be only opted in by the parties and the arbitrator. So, for example, if the arbitrator does not want to take this obligation, the arbitrator should not be enforced to do that. But if the arbitrator takes up this obligation, maybe with the potential application of liability insurance or whatever, then this is still a question, because when we are speaking about the arbitrator's liability, and of course we clearly understand that if the arbitrator makes an error when it applies this law in substance, then this is something against which the arbitrator cannot be held liable. but the issue that the arbitrator should produce an award which is at least theoretically enforceable and theoretically can be recognized by the jurisdictions which are in the procedure. This is something for which an arbitrator might be held liable. Of course, we do not know whether the Hungarian legislator would ever put these rules either to the Civil Code or to our Arbitration Act, but I think for consideration, for deliberation, this is a good issue. This is something which maybe could be a good tool. And what I think that since arbitration, luckily, is gaining more and more popularity, not only in Hungary, but in Europe and in the whole world. And since the cases related to arbitration become more and more complex, the liability of an arbitrator is a key issue and the key question. And there is one thing we cannot do. We cannot neglect it. Somehow we have to deal with that, either with regulations or with practice. But for the future, these are challenging questions, big questions, which need to be solved somehow. Ladies and gentlemen, many thanks for your kind attention. This concludes my short presentation, and now I'm more than happy to reply to your questions, if any. Thank you so much.
Thank you very much, Prof. That was very clear. I think you can stop sharing your screen so that, perfect, so we can see people's faces. Thank you so very, very much. That was really very clear. That was well structured.
Thank you.
I think that the issues that you have raised arise because of the tension between ethics and the liability of the arbitrator. And we go back. I think my view is we then go back to what's the role of the arbitrator? And we must accept that we also do have some poor conduct and poor behavior, which is leading, as we can see internationally, especially because we have information in the public domain in the investment law arbitration space, lots of challenges that are successful, because that is saying something to us. If we have lots of successful challenges to arbitrators, then the question we need to be asking ourselves is going back to maybe how we train people as arbitrators, and what is it that is the expectation of those who put themselves forward that they accept appointment as arbitrators, and the intention of those who appoint them.
That's right.
The market has become so fragmented that it's almost you're either pro this or you're pro that, which is not the job or the role or the function of arbitrators as dispute resolvers. So if we expect our judges to be completely independent, it begs the question why we think that arbitrators should not be completely independent. And that's what raises this whole tension and question. There is some research that was conducted by Professor Edna Sussman, where she was looking at liability insurance. And part of her finding, as at the end of last year, was that quite a number of those who act as arbitrators, especially independent practitioners like you and myself, well, you also act as attorney, and so you do have professional liability insurance. But for those of us who only sit as arbitrators, it was shocking to find out that the vast majority do not have any coverage, which is really super interesting that they have no coverage. And it's interesting that we are now beginning to look into that and understanding that there will be liability. And even if the arbitrator is forced to go before a court, they have to defend themselves. There's costs involved with that, and how. So those are one set of questions. The other set of questions is for those arbitrators that don't have terms of appointment. Because, of course, if you sign a terms of appointment, you then can include, you do have contractual provisions binding on the arbitrator and the parties. And then the third one, which is more, I think, more as a question, a philosophical question, is should arbitrators be enjoying any form of immunity anyway? And those are, I think, very interesting questions. And I'm going to turn to, I'll come back to you, Prof. I don't know if you want to engage with any of those while we wait for anybody who has a question. If you have a question, please just raise your hand or unmute yourself if you wish to speak. Yes, Mr. Wasuna, please.
Thank you so much, Prof. Onyema, and thank you, Professor Boóc. I hope I pronounced that properly.
Yeah.
Thank you for that excellent presentation. It was very informative, very educational as well. And I have learned quite a lot about the immunity and potential liabilities of the arbitrator. I just wanted to, if you didn't mind, pick up on your last point. And I was just sort of thinking it through in my head, particularly as it relates to as it relates to your potential advisory within Hungary on how to change the rules relating to the potential immunity of the arbitrator. And one of your very last points, and I hope I captured this correctly, was that there's the potential of the arbitrator and the parties agreeing that the arbitrator would be liable in a situation where the arbitrator renders an award that's not enforceable. And I just wanted to pick up on this point and pick your brain a bit on this. In a situation whereby, because I have come across it quite a bit, whereby the award is either enforceable in one jurisdiction and not in another, or in a situation where a challenge at the seat has been dismissed, but then it's not enforced in another jurisdiction, or the rarer cases where the challenge has been upheld at the seat and the award has still been enforced in another jurisdiction. How would that sort of situation be dealt with in such an agreement between the parties and the arbitrator?
Yeah, thank you for this question. You are absolutely right in that. And the reason why I dealt with this issue is coming from the same experience that we can have an arbitral award which is enforceable in country A and challenged in country B. And of course, the parties at the end of the day will be very disappointed, because what they see that we have been through an arbitral procedure for 1 year, 2 years. We have advanced huge costs. We have paid the arbitral tribunal, the arbitration institute, and so on, and still the award is not enforceable. And of course, I think it can undermine a little bit the credibility and the integrity of arbitrators from the party's view, of course, not from the council's view, but since we are, at the end of the day, we are councils who are, of course, living from our clients, and at the end of the day, you have to explain to your client what has happened and why he cannot cover the money and where he cannot cover the claim, because this is what it's all about at the end of the day. So therefore, I think that how it can be regulated, and of course, it only works if the arbitrator is cooperative in this issue, that at the beginning of the procedure, the parties and the arbitrator, maybe during the case management conference or at any other stage, might deliberate and might determine which jurisdictions might come up in this arbitration procedure. For example, of course, the nationality of the parties, this is the first question. But of course, the second question is where the potential asset of the parties are. Because as we know, it happens very often that we have a company registered in a country, registered, let it be an offshore country, and the assets are somewhere different, in a different place. And if those jurisdictions, or at least most of these jurisdictions, can be identified at the beginning of the case, then the arbitrator might decide whether the arbitrator feels and thinks himself applicable and available to provide an arbitrary award which is theoretically enforceable. Of course, the arbitrator under no circumstances will guarantee the content of the award, because this is something we cannot do. But as an arbitrator, we can opt in, and that's very important for me, that it can be done just with an opt-in procedure, that I take the obligation, that I know that we have in this arbitration procedure, let us say Hungary, United Kingdom, Germany, United States, we can identify those countries. And I think that the award I am going to render will be recognized in these countries, because I can guarantee as an arbitrator that there will not be formal problems. Of course, it's a huge commitment, I know. And I know that not many arbitrators would take it, but at the end of the day, I think it would lead to a healthy competition between the arbitrators. And since, in my view, arbitrators, to some extent, are service providers, it's not bad if there is a competition between the arbitrators. If we know at the end of the day that there are arbitrators who are careful enough, diligent enough to take up this obligation, while the others think that, all right, we do not take it. Of course, it's a question for the future. And I know how many obstacles there still are, but I think that finally, on the large extent or in the middle extent, it's able to develop the arbitration culture, and it's able to foster international arbitration. And I think for all of us who are arbitration practitioners or arbitrators, it is our most important interest to develop arbitration and to really prove that it's a good way for dispute resolution. So this is my answer to your question.
Perfect. Thank you so much, Professor. Thank you.
Most welcome.
Thank you, Prof. Let me push a little bit on that. Right. And I agree that we need healthy competition because we're providing services. But I'm just wondering whether we are not already seeing some form of healthy or unhealthy competition with the appointments process. Because we know that parties they have people they appoint. And just thinking about this in the context of greater inclusion, of we want new faces, we want new names coming into the community, the question then becomes, why do we want to force this healthy competition? Because the way it's been described, I would not sign terms that says I'm going to be personally liable, because it's not my dispute. It is the party's dispute. My job is to resolve the dispute to the best of my ability. There is no law anywhere that says that if my decision is incorrect, except where it is blatantly incorrect, but that's to the best of my ability, that I should be held liable. Because the parties choose the arbitrators, so they live with whoever it is. That's their risk. They choose the arbitrators. Right. So why should I then sign up and say that I would be happy to be held liable just because I want to promote healthy competition?
Yeah. I understand your concerns and I understand the question. And the way how I think it is that, of course, in these cases, the arbitrator should have a coverage, should have insurance for that, for sure. It only shows that what I would like to avoid, that the arbitrator is really doing according to his best knowledge, but at the end of the day, the award is not enforceable in all of the countries which are known. Of course, that's a different question, that if after the procedure is closed, somehow out of the blue comes up a new jurisdiction which wasn't known, this is something the arbitrator, of course, cannot do anything. What the arbitrator maybe might take as an obligation, that according to best knowledge, according to best experience, and so on, the award should be recognized and should be enforced in the countries which are enlisted. So, for example, as I have told you, the home countries of domicile countries for sure, the country where arbitration is done, and maybe those countries which are clearly identified by the parties. For example, we know that party A has a domicile somewhere, and we know at the beginning of the procedure that the main assets are somewhere in a totally different jurisdiction. So I think this is something an arbitrator might take. And of course, I understand the concerns that the arbitrator should not have maybe a personal liability, but maybe the liability insurance. Why not? And because otherwise, because I think that somehow it is really able to give a sort of quality assurance to arbitration, that it's something which is quality, because and it can show that we are as arbitrators and arbitration a real alternative to state jurisdiction, because finally this is what we want, that the parties should rather go towards arbitration instead of state litigation. And of course, in some countries where state litigation has some shortcomings, for example, it's slow, for example, it's even expensive, then it's a real alternative. But still, I think somehow we can foster arbitration also with these tools, which I can regard as a sort of quality insurance.
So, Prof, thank you very, very much for that clarification. Just to keep in mind that this is a community that is risk averse.
That's right.
And so we know what had happened when some Middle Eastern countries were like, criminal liability and all of that. And people said, no, they would not.
This is something different. Yes, of course.
Exactly. And I was, with the Nigeria versus P&ID situation, for example, where we had really top, I mean, you don't get bigger than that, arbitrators, and the award was still set aside. And for in the home jurisdiction of the majority of the arbitrators. And that is simply a risk that we need to maybe clarify. Because if the grounds on which the award is set aside is not the fault, or as a direct consequence of an action or behavior by the arbitrator, my view remains that arbitrators should not be liable.
That's right.
I think we need to link your suggestion to an action so that there's personal responsibility by the arbitrator. I see that Mesoma has switched on her camera. Did you want to say something? Please unmute. I think you can unmute.
Oh, so sorry.
Yeah, please
sorry
go on. Please.
Yeah.
Please.
I heard someone saying about incorrect decision in arbitration. As someone who has mastered it in international arbitration and global governance, I would say that I'm just giving an opinion on that statement. I would say that what actually distinguishes arbitration and has made it as a good tool of global governance in the recent time, especially dispute resolution, is the very fact that the arbitrators sitting over or presiding over the disputes is an expert in that field of dispute. So saying something like we are having incorrect decision is something that we can seldomly experience, is not something that should occur at all, because what keeps the arbitral proceeding steady and have some level of standard practice is the arbitrators and the arbitral institution.
That's right.
So that's exactly what I just want. I wanted to correct that impression of incorrect decision.
That's right. Thank you. Thank you.
Thank you.
And thank you very much for picking up on that. I think the statement was that there's no law that says even where the decision is incorrect, the arbitrator will be held liable.
That's right.
And you do have incorrect decisions by arbitrators. I mean,
That's
arbitrators are not infallible. So we're hoping that we will not get incorrect decisions. But quite a lot of jurisdictions, if the decision is incorrect, depending, I think a lot depends. This is where you have, it depends. Some courts would still not set it aside, and they would
That's
say,
right.
well, it depends, that's who you chose. And in some courts, they may set it aside. Thank you very much, Mesoma, for that comment. That's very kind. Is there anybody else that wants to say anything else? So, Prof, I think we've given you a lot to think about with your recommendations to the Hungarian lawmakers. Mark, please go on.
I'm really sorry. I
please.
just wanted to just add one small point. Just when Prof. Onyema was talking about inclusivity, I was also just thinking about and she sort of touched on this briefly, like young arbitrators getting into the field and whether they would be comfortable signing such an agreement, and whether really it may negatively impact on sort of young arbitrators getting involved if they were required to be personally liable. So it's just a small point to sort of consider as well in this discussion. I didn't know whether you had any thoughts. Yeah.
Thank you very, very much, Mark, for raising that important point, which Prof would also need to consider, because I think there are various ways we can deal with this. Ultimately, the concerns that Prof has, they're very, very clear. We want people to go to arbitration, but if we want people to go to arbitration, then they need confidence that it's qualitative people that would resolve their disputes. And I think that's a fair balance. It's how that is resolved. And so what we've listened to is Prof sort of reminded us of the theories of the arbitrator and the different types of immunities that we have. I like the game theory approach to identifying the applicable law. And this really important point about the interests of the arbitrators if we rely on their domestic law, as we can see, and that's what the focus of our conversation is being. I like the idea with the to hold on to the provisions of the law of the seat, because then that gives power to the parties in selecting the seat, but it's also almost like a neutral venue. It doesn't even matter if an arbitrator comes from that seat, but at least it's a more neutral ground, and that law would apply equally to the whole tribunal. So I think that's important. I think that we can see quite a number of institutions now are reducing fees.
That's right.
Prof raised that point. And so maybe the community itself is finding ways to deal with some of these issues around delays in completing the task by arbitrators. But where there is absolute poor behavior, the community needs to deal with it. And maybe, Prof, one of the things to really consider is, should the community be excluding people? Should we, because part of our problem is that we don't have an overarching regulator. Should the community be excluding people who have behaved very poorly so that we can take our tasks and our role as arbitrator very seriously? And that is of concern to Prof. And of course, Prof raised this whole idea about insurance. linking the healthy competition back to insurance. And I think that insurance is important. I have insurance anyway, so I think it is important. I think it's an important link. But then, Prof, you do need to think a little bit more around exclusion, so that it's not so onerous that good people will be excluded from sitting as arbitrator.
That's right.
Prof, thank you so very much. We're very grateful to you for accepting our invitation to speak to us this afternoon. Prof has sent us his slides. We have them in PDF, but I have no clue how to attach the slides to...
I couldn't do that either.
So both of us have no clue how to do this. So what we'll do is we're going to email it to all those who registered via our Eventbrite page. And so this brings our webinar to a close. Prof, thank you very, very much.
Thank you, Raj. It has been my real honor and my pleasure to be with you. And in the future, I was also very glad to come again with other issues.
We will definitely have you back. Thank you very much, Prof. Okay.